Hello, I'm Martin Pritikin, the Dean of Concord Law School at Purdue University Global, the nation's first fully online law school. Welcome to this latest installment of our Distinguished Speaker webinar series on the topic of immigration in America today, law versus politics. And this is obviously a very timely topic given everything that's been going on in the news right up to the last few days. It's also a particularly pertinent topic for our students and graduates, given that immigration law is one of the areas that an online law school graduate can practice anywhere in the country. It's also a reason why we've recently added an immigration course to our curriculum. Now, our distinguished speaker for our Distinguished Speaker webinar today is Hiroshi Motomura, who is the Susan Westerberg Prager Distinguished Professor of Law at the UCLA School of Law. He is also an internationally recognized expert in immigration law. He has co-authored 2 textbooks on the subject and written 2 other books, with the third one on the way with the support of a Guggenheim Fellowship. His books have won numerous prizes, including the Association of American Publishers Prose Award for the best book in law and legal studies, not just once, but twice. Professor Motomura himself has won numerous awards for his teaching, including recognition as a President's Teaching Scholar from the University of Colorado, the Distinguished Teaching Award for Post-Baccalaureate Instruction at the University of North Carolina, Chapel Hill, and UCLA's Distinguished Teaching Award. He served as a member of the American Bar Association's Commission on Immigration, is one of the co-founders of and current directors of the Rocky Mountain Immigrant Advocacy Network, and he serves as a vice chair of the board of directors of the National Immigration Law Center. He's also served on the board of governors of the University of North Carolina Press, and is a member of the editorial board of the International Migration Review. Perhaps not surprisingly, Professor Motomura has been invited to testify before Congress on the topic of the subject, and so we are very privileged to have him speaking with us today. So first of all, Professor Motomura, thank you for joining us. Thank you for taking the time.
Well, thank you for having me. Glad to be here.
So the reason why I wanted to call this law versus politics is that obviously people feel very strongly about this subject and related topics within the subject of immigration on either side of the political spectrum. But I wanted to try and maybe help set a baseline and see, okay, when we're debating about things, is there any law on the topic? Are we debating over any legal precedent or legal principles? Or is it really just policy preferences about what people would like to see happen? So let me start out by trying to set the stage before we get into particular topics. What does the Constitution, the ultimate source of the law in this country, what, if anything, does the Constitution say about the topic of immigration?
Well, I'm really glad, Marty, you're starting this way, because I think it is a tension between law and politics. And I think that's precisely the right way to think about this in a law school setting. So to answer your question, though, the Constitution has surprisingly little to say about immigration explicitly. A lot of people think that it says a lot about immigration implicitly or necessarily. And the reason I say that is that you would think the Constitution would say this is the immigration power, this is what Congress can do, this is the president can do. It doesn't really do that at all. So a lot of people, a lot of scholars of immigration law and constitutional law have read into the very creation of the nation certain things that might bear on immigration. And one of them, of course, is national security. Another is what it means to be a people. Another is the idea that there is something called citizenship that we associate with countries. And so these are all the ways in which the Constitution is believed to speak to immigration without actually talking about immigration. You know, curiously, and I think very interestingly, and it's worth noting that the one place where the Constitution actually talks about migration is in a reference, I think historians believe, is a reference to the slave trade. And so there's a reference to migration, which seems to be associated with slavery, but it's also interesting that the founders could not bring themselves to use the word slavery in this document. Right. And so to answer your question, the Constitution says a lot of things that have been taken to address immigration, but it's not as if it really lays out a blueprint.
Now, the Constitution does have a naturalization clause, correct?
That's right. That's right. And so that was one of the things I mentioned, that there's citizenship, there's national security, there's what it means to be a nation. And so there is, so that's an area in which the Constitution doesn't address immigration, but it addresses citizenship. So then if you take the view, for example, that the Constitution by addressing naturalization, becoming a citizen, in other words, not by birth, but by application. If you take that as implying something about Congress's power, I'm sorry, the Constitution addressing immigration as sort of a precursor to citizenship, then you could say that the Constitution addresses immigration. But so it's a couple, as is often the case, it's a couple ways to take your question. I mean, if you ask about immigration, much less so. If you ask about citizenship, naturalization clause.
Right. And by the way, just a note for our audience members, since we are streaming on Facebook Live, if you do have questions you'd like asked, feel free to post them within Facebook Live. Certainly no guarantees we'll be able to get to them. A lot of topics to cover within an hour on immigration, but we'll do the best we can to try and weave them in or possibly save a few minutes towards the end for that. So the Constitution doesn't say a lot, anything really expressly about immigration as a whole, but how has the law developed in terms of Supreme Court precedent or otherwise to form our current picture about what the federal government's role is in controlling immigration? And I'm going to ask about Congress's power versus the president, then we'll talk about the federal government versus state government as well.
Yeah, I mean, there are a lot of different angles of that. And let me just list them and then we can get into each one. But sure. I think if I were to answer your question completely, I mean, that's probably occupies about 3 hours of a course or something, right? But so let me just lay out the groundwork here. You mentioned a couple things that are important. One is the Congress and the president, right? So Congress has immigration statutes. President is in a position to interpret them, but also to make some choices, for example, about enforcement. So that's one big issue. Right. I think we've seen examples of all these in the news, actually. But let me just mention them. I mean, so Congress and President. Congress has statutes. Okay, so there's been a historical reluctance on the part of the courts and the court system for judges to jump in and say to the president or to say to Congress that something that is done, let's say Congress passes a statute, the courts have been reluctant to jump in and say, well, that's unconstitutional. Similarly, the courts have been reluctant to come in and say, we're telling you, Mr. President, what you're doing is unconstitutional. There's been a sense that these are often very sensitive issues, sometimes involving foreign relations and national security, and sometimes the standards are really hard to figure out. And so the courts have tried to, there's something called the plenary power doctrine, but that's just a fancy word for saying the courts are reluctant to jump in. Okay, so in addition to the Congress and the president, which is the first thing you raise, the second question is how the court's going to jump in. Reluctant to, but there are exceptions. And another thing that I want to flag is the relationship between the federal government and the states, because one of the things we're seeing right now is that states have been really trying to make their own policies. This has been true not just in this administration, but it goes back quite a ways. And so states are trying to make their own policies. And so there's a body of law that is on each of these points. And it depends a little bit on what the issue is. And a lot of the issues we've seen in the news, certainly in this administration, but it really goes back 125 years, have been trying to figure out exactly where the prior law, Congress and president versus the courts, and the federal government versus states. And that's only the big themes, and there's more, but that's kind of an overview to answer sort of what the issues are. And those are all kind of grounded in the Constitution in one way or another.
Well, so let's talk for a minute, speaking of Congress versus the president, right? Obviously, there's been a lot of talk in the news in the last few days. President Trump on Friday announced he was declaring a national emergency in order to be able to get funds to build the border wall. As of this morning, I think the latest tally was 16 states have said that they were going to be suing him over that decision. I know it's as much of a constitutional law issue or more than it is an immigration law issue, but let me ask an initial question. Is there any precedent for a president declaring a national emergency with regard to an immigration-related emergency?
Well, the short answer is yes, but there's a big but following the yes. Okay, I mean there have been a lot of declarations of emergency in the last since the statute was enacted that is being used for this purpose by every president, really.
And you're talking about the National Emergency Act of 1976?
National Emergency Act, yeah, exactly. So a lot of these emergencies then, a lot of the declarations involve an immigration component, but it's very narrow typically, much narrower. So for example, I pulled up a list of these things before. today and see that you have President Obama imposed sanctions on individuals contributing to unrest in Burundi. Okay. Now, as part of that, that includes sort of asset controls and things like that. There's a very limited part that says we're going to deny entry to the United States to people who are listed as bad actors in this sense, and they could be contributing to unrest in some way. They could be persecutors or whatever it might be. But so the answer is that there are immigration-related aspects, national emergencies, but this is a very broad and in that sense unprecedented declaration involving a much wider scope of things, and also its relationship to Congress and what Congress has done or declined to do is different.
Now, you mentioned that the courts are reluctant to step in and rule any congressional presidential action regarding immigration unconstitutional. Are there any precedents where they actually have done so?
Yeah, there are a number of precedents when they've done so. So, I mentioned that's the general rule or general presumption that courts don't try not to jump in and say something's unconstitutional. But there are cases when courts have stepped in and said, what you've done in a particular situation, you meaning either the president or Congress, is your immigration officers have denied due process to someone who is for example, a returning permanent resident. Someone leaves the country, comes back, and says, "Let me back in," and courts have jumped in. And I'm thinking of a 1982 case that's a landmark called Landon versus Plasencia. A court says, "Well, this violates due process. You need to provide a hearing. You need to provide notice of a hearing and things of that nature." That's an example. And so the courts do that. But I also want to emphasize that the doctrine that says the courts don't jump in and declare things unconstitutional unless there's a real reason for it, that doesn't keep the courts from enforcing the statutes as written. So the distinction I'm making is, I think when you drew in your question, which is the courts are reluctant to jump in and say that congressional statutes are unconstitutional. Courts are reluctant to jump in and say to the president, what you're doing is unconstitutional. But courts are quite willing to say, dear Mr. President, you have misread the statute. What you're doing violates the statute that Congress created. And that's often what's been happening in the last, I was going to say the last couple of years in this administration, but it's been true really since their federal immigration statutes. Courts have jumped in and said, you're reading it wrong. You're trying to do something that violates the statute. And that's less of a tall order for courts to do. So I think it's important to think about, is the law here, to go back to your framing of this webinar, is the law here in the statute? And is the argument that it violates the statute, or is the law here that the Constitution forbids it?
Well, I think that raises another important related issue, which is that isn't it the case that Congress has delegated a lot of authority to the executive branch to make, if not statutes, regulations that for all practical purposes function as the operative rules that govern what happens with immigration cases or immigration policy. Can you speak for a little bit about what the history is, what the background is about Congress delegating that authority to the executive?
Yeah, that's a really good way to carry this conversation forward, because as you in your first question, the Constitution doesn't have a lot to say expressly. So Congress starts creating these statutes. That's a whole history we can get back to if you want, but I mean, Congress starts making them not from the beginning, but starts making them in the 1870s. So this country has roughly almost 100 years before there really are immigration statutes. Whole history behind that. But anyway, so what you have is Congress creating these statutes. You're absolutely right. Congress leaves a lot of gaps, as it often does in any field, right? And so there are voluminous regulations that do everything from define terms to set up procedures and things like that. And so that's absolutely right. And so a lot of times what you'll have in situations is the president will issue a regulation, and then the regulation will be challenged. Sometimes because the regulation is alleged to be unconstitutional, but also because the regulation is alleged to be inconsistent with the statute. And that's a frequent move in administrative law. It's especially true. I wouldn't say especially true, but it's definitely true in immigration law. But I also think it's, there's the last part of the answer to your question to try to fill this out. It's not just a kind of a traditional hierarchy of constitution, statutes, regulations. There are things that are also what's going on, and that is that there's a great deal of de facto on the ground discretion going on. And so there are regulations that define a lot of things and create a situation where some people might be out of status. Some people are really kind of in this zone where they're not supposed to be doing something or they're required to do something, but so much of the law in this area is being made on the ground by line officers, field officers deciding whether to, let someone go, deciding not to pay attention to them. This is true in all law, of course. I mean, it's true when we drive, right? I mean, we could be driving on a speed limit. But what makes it different, I think, in immigration is not this mechanism of discretion that, law enforcement, not just law enforcement, but just bureaucrats apply, but the stakes here. I mean, if you might get a parking ticket, you might get a speeding ticket, that's discretionary. But if you're arrested, as it's quite possible that the consequences of that are deportation.
Well, so this raises so many interesting questions, and I want to go with the flow of the conversation, but I also want to give it some structure here because
sure,
everything's connecting everything else.
No, I understand that. Yeah.
No, it's good though. Let me actually ask a question, going back to the national emergency issue. And actually, this is a question I wanted to ask anyway, but I see that one of our audience members asked virtually the same thing. A lot of people were happy and a lot of people were upset when President Obama promulgated DACA, right? Deferred Action for, actually, I forget what the CA stands for.
Deferred Action for Childhood Arrivals.
There you go. Thank you. Right. Also known as Dreamers, colloquially, right?
Yeah.
And so, some people were very happy about that. Some people were very upset. Now we have people who are very happy or upset with President Trump declaring a national emergency to build a border wall. And so the question is from a legal perspective, not just again from a policy preference perspective, but from a legal perspective, is there any difference between what President Obama did with DACA and what President Trump is doing now with the National Emergency Declaration?
Yeah, well, I mean, I can see why they look the same. I can see why superficially they look the same, but I think that they're different. And here's the reason. And there's different ways to explain this, but let me try this one out, and you can tell me if this is one of those hypotheticals that doesn't really work. But what happened really with DACA is that Congress has for a long time, I mean, in some sense, continuously for the last 15, 20 years, considered different legalization programs. And by legalization program, I mean a program that would give someone who's in the country without legal status, whatever term you want to use, illegally, undocumented, irregular. The Congress has considered laws that would give those folks a green card, permanent residence. In other words, that's a status that allows you to stay indefinitely. You can apply for citizenship, but you're not required to apply. So green card. So Congress has considered laws that would give a lot of folks green cards who are currently in the country without status. And considered those laws, and Congress has never really enacted one. Last time it really enacted something that scale was back in the 1980s. So then Obama comes in and he does something that, this is the core of the answer to your question, he does something that doesn't give people green cards. He doesn't put them on path to citizenship. What he does is he says, well, we don't have the resources to deport 11 million people. And so we're going to give some people, tell them that they're low priorities for deportation. So the difference that matters is that there's a huge gap between what DACA gives these so-called dreamers and what Congress refused to give so-called dreamers. Obama only gave them a very small fraction. He was really operating in a very different space. What you have here in this situation is Congress deciding not to appropriate X dollars, and then the president saying that he's going to spend X dollars. Now, the counter argument, of course, is that this has been provided for by Congress. And so then you get into the space about, does it fit into the National Emergency Act? So that's a different question. But I'm trying to address the difference between DACA and this declaration. That it would be equally troubling to have done DACA if DACA was to give people green cards. But DACA didn't do that. And so DACA operated in the space. This goes back to an earlier question you asked, or at least an earlier answer I gave, that Congress, the president has all kinds of discretion to spend money to and decide, what the priorities are for arresting people and deporting them. And so the Obama administration was operating in that space that Congress gave, and was, I think, quite careful not to give people green cards. In fact, that was the whole. I think they're very, very clear about that. And so, in that sense, the two things look alike. But I think a lot of the folks who criticize DACA, I often see in criticisms of DACA that it really tried to override what Congress did, and I think that it didn't do what Congress rejected doing.
I hear what you're saying. So, it makes me think of, by analogy, right? And I don't know if this is a good analogy or not, but I'm just thinking about it. The Attorney General of the United States, right, overseeing the DOJ, can decide whether to make marijuana prosecutions, right, a priority, which change from one administration to another. So you're saying, if the president is saying, Congress has told me enforce the immigration laws, I can use my discretion to decide what's a priority and what's not, right? So you're saying that's within the bounds of what Congress did, but the argument would be on the other side. Congress has said you can allocate X dollars for this and not for that, and for President Trump to try and declare an emergency in order to allocate those dollars elsewhere, that arguably is going against Congress's appropriations decisions. Would that be a fair summary of the argument?
Yeah, I mean, I think what you're raising is conceptually accurate. I think it's like, there's a lot of different analogies, and some of them are going to be more reach different people in the audience differently, just in terms of their own experiences. But I mean, I think your way of looking at it resonates, or at least harmonizes with the fact that these states are suing, because what the states are suing and saying that they have standing on this is because what's at stake here is dollars that were appropriated in ways that should be spent on any number of things, And so I think the argument against, why this is not, like DACA, is because this is more in the face of a congressional decision. Now, of course, the counter argument, which I'm not really, I'm going to confess not knowing enough about this particular act and the history of, this is really more, as you said, sort of a mainline con law question. But the argument really is that in the act, the Congress gave a lot of power to the president that presidents have used. And so that would be the argument. I understand that the argument being raised by the states is that this is much more in the face of a congressional decision and involves appropriations, and particularly the power of appropriations and authorizations that puts it in its scale. It's not only a scale difference, but it's also a difference in terms of against the congressional budget decision that was made. And of course, then you get into the whole question about whether it's really an emergency.
Right, and that raises, again, I'm going to get to that in just a minute. So I was actually doing a little bit of homework on the National Emergencies Act myself, because I wanted to understand how this fit in. So what I learned is that in the 40 years since Congress passed the NEA, I guess a little more than 40 years now, in 1976, I think over 50 national emergencies have been declared. Not all of them are things that you would obviously think of as an emergency. Obviously, after 9/11, President Bush declared an emergency. I don't think people would, take much issue with that. Right. But the way the statute works is that every 6 months, Congress can review the presidential action and vote to say, no, we don't agree. That's not an emergency. So far in the history of the act, Congress has not only never overturned a presidential decision based on a declaration of emergency, but I don't think they've ever even met for the purpose of discussing that. So this would at least be a departure from historical precedent at that point if they did so. I would imagine the argument would be, look, just like Congress gave up a lot of authority to the president to declare an emergency under the National Emergencies Act, they also reserve for themselves the right to overrule that effectively. And if they choose not to exercise that authority, well, that's on them. But there's at least a political solution, which maybe means the court would decide not to get involved and say it really is a political question.
Yeah, I mean I'm not in a position to really have any confidence in a prediction about what courts will do in this case.
Yeah.
But you're right. Some of the, I think, criticism, or at least maybe buyer's remorse on the act, the statute here, NEA, is that it gives president quite a bit of power. And so the debate is really going to be: is this really not the kind of power that was given? I mean, if you look at the list of emergencies, including the immigration-related emergencies, or maybe especially one to focus on the immigration-related emergencies, they're extremely narrow, as I mentioned earlier. That these are situations where you have asset freezing, particular groups, really small groups of people, in many cases. In that situation, it's part of asset freezing to deny entry to what in some cases is just a few dozen people, or could be many more. But at any rate, it's a very specific thing focused on, as I mentioned, the example of unrest in Burundi. And so this has been true in other situations in response quickly to crises that are international but often narrow in scope. So this is what's different. I'm not sure how it's going to play out in the courts. I mean, it's obviously part of a larger picture of politics at different levels, having to do with, of course, the federal budget and the budget shutdown, but of course the wall and everything that's played out in immigration with this administration.
Well, let me ask you a question. You may or may not have an opinion on this, but because this is, again, maybe more of a methodological question or jurisprudential question in terms of how courts consider these issues than immigration per se. But you mentioned what the court might look at in deciding whether this is an emergency. And one of the things is that President Trump Friday or over the weekend said in a press conference, he said, well, I didn't have to do this, right? But I figured it's quicker and easier to just declare the emergency. That way I'll get the money for the wall. And so obviously his opponents have pounced on that, and they've said, aha, he's basically admitted that this is an emergency because he said he didn't need to do this. With the travel ban, at least some of the lower courts did consider his earlier statements, including during his campaign before he was president, as evidence of what the underlying motivation, so to speak, was of imposing the travel ban. Do you think that's appropriate? Do you think that's something the court's likely to look to in terms of his statements about his motivations in assessing whether it is a legitimate emergency or not?
Yeah, that's a really good analogy, and I've been wondering about this. There's a couple of ways to think about this. I mean, one is to go back to the baseline that you mentioned, which is that the candidate Trump and the early President Trump and other people speaking on his behalf, the part of his inner circle, at least at the time, said that I'm basically anti-Muslim statements, sort of really saying we need to keep Muslims out and things in that direction. I mean, it was said in different ways, and so I'm not really I'm lumping together a lot of different statements. But you're right, the lower courts picked up on that and they assigned meaning to it. There's a couple of differences here. Is that the travel ban, the Muslim ban, a lot of different terms are used, but the ban we're talking about that ultimately was allowed to go into effect by the U.S. Supreme Court, that went through several different iterations. In other words, that what happened is that the version that the Supreme Court upheld, or I want to say allowed to go into effect, because that's actually what happened. There's still that was just on a preliminary basis. The court allowed to go into effect the third version of it, and the third version was one that reflected a lot more stated justifications. I mean, there's a lot of back and forth, and a lot of people who are national security experts, including in other administrations, prior administrations, said, well, this is, those officials and experts questioned whether the national security justifications were real or just made up after the fact. But be that as it may, I mean, we're dealing here with something that, as an emergency declaration, is really would be, we're just at the stage, would be like the first version of the travel ban. Now, I suppose the analogy would be if the White House were to come in and say, well, I said, last Friday that certain things, I just want to do it faster, but I thought about it, and that's not the real reason. It's really an emergency. So that would be one thing. But here's another thing which I think is important, and actually, in some sense, more important. I think one of the reasons that it was a 5-4 decision, of course, in the travel ban. One of the reasons why that was ultimately allowed to go into effect is because it affected people. The court thought about it as affecting people outside the United States. In other words, really saying we've got a border, a legal border, not a physical border, but we're talking about not letting people in from outside the country. And so they really conceptualized it as an issue where we don't have to treat people with the same constitutional protection outside the country as inside the country. So that's really different from a situation where we have billions of dollars at stake affecting budgets all inside the country, right? I mean, the people claiming that the border wall emergency is a violation of Congress's spending power are people in the United States who say they have a call on that money based on what Congress said. So that's a huge difference. It's a really huge difference that I think affects, in the end, how seriously the courts take statements by the proponents of whatever it is that's being attacked, whether it's a travel ban, entry ban, or whether it's an emergency declaration in terms of building a wall.
It's interesting to me because on the legislative side, there's obviously a lot of jurisprudence about how and to what extent courts will consider legislative history in interpreting the terms of a statute. Well, here, when you have executive agency, or not even agency, right, presidential decisions, there is no legislative history, so to speak. So it's interesting what the jurisprudence is or will or should be regarding the presidential analogy to legislative history, right? Statements made to the public about what the motivation was, how much does that affect the interpretation of the actual presidential orders themselves? You mentioned, though, right, this idea that with the travel ban, the court looked at it a certain way because they were dealing with non-citizens outside the United States. I think this is an important topic, and we're about a little past halfway, and I want to make sure we get to this. It's a big topic. A lot could be said, but I want to sort of lay the groundwork by talking about the different categories of immigrant status and what those rights are. So to my layman, so to speak, view of it, there's citizens outside the United States, there's non-citizens outside the United States, there's citizens and non-citizens within the United States, and there could be perhaps more subtle nuances depending if someone has the status of an asylum seeker, legal non-citizen versus, non-legal non-citizen, whatever the case may be. But let's sort of start in steps, right? So do non-citizens outside the United States, under the Constitution or any interpretations of any statutes, does American law give them any protection to not be discriminated against, due process? Do they have any rights like that? Have any rights been recognized, at least?
Yeah, well, I've taught a 56-hour course that answers your question. But
okay.
Much time. Let me just say.
You got about 5 minutes, so.
Yeah, no, or less. So the border does a lot of work here. I think that there are situations where people outside the country have rights, and let me try to quickly sketch when that might happen. I mean, first of all, a lot of times people outside the country have rights in the sense that they can insist the U.S. government do something, right? That's really what we're talking about. And sometimes it's based on a statute that gives them that right, I guess if you want to put it that way. In other words, statute requires them to get treated in a certain way. And another times is when the Constitution might apply. Okay, so we're talking about someone outside the United States. I think as a general rule, it's very difficult for someone who has not been in the United States ever and has no connections with this country to assert rights under the Constitution. It's often said, if you're on the outside knocking on the door, and courts have said in a number of situations, well, the Constitution doesn't protect you. I guess there's some intuitive sense of that. But even in the way I phrased it, I mean, there are ways that there might be other ways that someone could say you don't have a right to a certain kind of a right on the Constitution. So one of the things that if you have a situation where someone applies for, let's say someone who's outside the country marries a U.S. citizen, and they go to a consulate or embassy, U.S. consulate or embassy overseas, and they want to get a visa that will allow them to come to this country to join the spouse as a green card holder, as a permanent resident. And the consular officer says, "Well, we're not letting you in." And this foreign spouse says, "Why not?" And the consular officer says, "Well, I don't have to tell you." Okay. Well, so then they say, it's national security or something like that. I'm not going to tell you. Or they don't even say that. They just say, "I'm not going to tell you." Well, I mean, I think that, so this is one of these cases where the argument would be there's a procedural due process right under the U.S. Constitution here. Now, this is
for the citizen spouse or for the non-citizen spouse in the other.
This is really the question here, right? I mean, in some senses, I deliberately chose the scenario of the spouse because it's really hard to separate the spouses, the interests of the two spouses here. So there's a case from a few years back where it's one of these splintered sort of Supreme Court decisions where there's discussion about what the rights are here. And the court really does focus on the rights of the U.S. citizens, the U.S. citizen spouse in the United States. But as a practical matter, this is a situation where the couple is, I'm just looking at it practically now, they really funnel it theoretically through the U.S. citizen, but it's a situation where this couple, as a practical matter, tries to say, "I'm entitled to due process, I'm entitled to at least know the reasons for denial." And the court is splintered on this question. I mean, I read the court as saying the procedural due process does apply in that situation, but then they splinter over exactly what process was due, and the court ends up deciding that enough of a reason was given. But to circle back to your original question, I think that historically it's been hard for non-citizens who are physically outside the United States, who have no connection to assert rights. But in many of these cases, what happens are two kinds of situations. One is where there's enough of a connection with people in the United States that makes a difference, and because someone is heard inside the United States, often a U.S. citizen, and another, I mean that's probably that's the main thing. And so what I found troubling about the decision on the travel ban is that I can understand how the court was saying to someone who had no particular connection to this country why they couldn't call on the Constitution. What I found under justified and really unjustified was the court not really placing much weight on the rights of people inside the United States who were really adversely affected by this, including and maybe especially spouses who couldn't live with their partners inside the United States. And I was actually thinking, and I'm not saying predicting, but I was thinking that Justice Kennedy, having written a decision emphasizing the value of the family and emphasizing, in effect, that this is a same-sex marriage case, emphasizing, hey, you don't have to go move to another country to live with your same-sex partner as a spouse. We don't make you move to that. He would not necessarily say that the Constitution applies outside the country, but would put significant weight on the ability of a U.S. citizen spouse to live here live here in the United States, as it'd be similar to saying, well, just because you live in, if you can cross a state line if you want to have a same-sex marriage. He didn't say that in that case, and so that
is interesting.
A bit. And yet I can, the border does work here again, right? I mean, the border does work just in the sense that Kennedy obviously thought that there was some difference. I mean, the complication with immigration law, what makes it so hard is that I think for some people, it's an issue where the border does a lot of work. It makes a big difference. And then we can neatly divide between insiders and outsiders. And I think a lot of other people, this is partly a legal question. It's partly a sort of a comment on the politics of this, is that a lot of people will push back and say, well, wait a minute, you really can't decide between insiders and outsiders because we live in families with different statuses. We live in a global economy where employers are hurt if they can't bring in people. We live in that kind of situation. And so those folks would say, the border is doing too much work. The line isn't as broad as you think. And that's a source of both legal controversy and I think a lot of political controversy.
Right, right. Well, and so what about undocumented, illegal, whatever term you want to use, right? Non-citizens living inside the United States. Well, let me focus on undocumented immigrants. Do they have rights to due process, rights not to be discriminated against? What does the Constitution or precedent say about that?
Yeah, so that's a nice, that follows nicely what we just talked about with people outside the country. People who don't have legal status in the United States, courts have given them, really anyone who's in the United States, regardless of their legal status, much more recognition under the U.S. Constitution. And the reason is because they're in the United States. And so I can give you sort of the core minimal justification and then a broader one. The core minimal justification is that they're subject to the power of U.S. law. They're on U.S. soil. Here, the conceptual work the border does is to say the Constitution applies for sure inside the country. We might take into account the fact that someone doesn't have legal status, but it doesn't mean we can do anything we want to them. We have to give them a hearing. They're entitled to due process. So in that sense, we see a number of decisions. I mean, the landmark decision on this is Plyler versus Doe, Supreme Court, U.S. Supreme Court, 1982, that says that states cannot keep undocumented, kids out of K through 12 public schools. This was the case arising out of the state of Texas. But there, other cases where people, even after they've been, there's another case from 15, 16 years ago of actually a 2001 case that says that even if you've been ordered deported, you have rights under the Constitution. In other words, even after your green card has essentially been revoked. So that's really the legal answer to your question. I mean, the policy answer to your question is something that replicates in debates over legalization, and that is that it really gets kind of the history of undocumented immigration in this country and why it is we have 10, 11 million people here. I think that, on one side of that political spectrum, you'll say there are people who say they're here illegally and that's it. And so they really shouldn't have constitutional rights or even, have policy claims to legalization. And other folks, and I guess I would include myself in the second camp, look at the history of this and see that a lot of the reason we have 10, 11 million people in this country is we have a system that relies on their labor, and we've never essentially given them a line to stand in. We've kind of invited them here and have a policy. We'll look the other way until once in a while we'll deport you and be shocked that you're here. But and that way of looking at it, I think, is one that you hear a lot in the arguments about why they maybe should be given some kind of legal status. It's really a form. One way to think about it is that they've earned their way to legalization. The other way to think about them is that we invited them here. Of course, not legally, not by law, but by practice that people understand. And to some extent in law, because there are certain aspects of law that really have a wink-wink quality to them.
Well, so let me ask about a specific subset, or I'm not even sure if they would qualify as a subset. You can speak this better than me, but I'm interested in the topic specifically of asylum seekers, right? Yeah. Because, recently it was announced that asylum seekers who traditionally would remain on U.S. soil while their asylum petition was pending, at least those coming up through the southern border, where actually an arrangement was reached with the Mexican government to have them wait on Mexican soil while their petition was pending, which, not being as familiar with the topic, I didn't realize it was such a departure. So do asylum seekers in particular have certain rights or certain protected status that other non-citizens don't have? Is that a bigger deal to do that for asylum seekers and for other immigrants?
Well, I mean, there's a couple of ways to approach this. I mean, asylum seekers that we hear about in the news are people coming up to the southern border of the United States. Often, maybe the group that's drawn the most attention has been from Honduras and Guatemala, El Salvador, and of course, but there are others, other nationalities represented. Those folks are outside the United States. Many people apply for asylum inside the United States, and so that would fall. That group of people applying inside the United States would really be subject to the protections that apply for people on U.S. soil. Okay, so there's that. And by the way, many people apply for asylum who are in legal status, and there could be a coup in their country or something like that. And that's getting a little bit away from your question. But I just want to point out that not all asylum seekers are outside the United States. So the asylum law is set out in a lot of different sorts of legal documents. I mean, we have a treaty that the United States is a party to through actually a series of documents and events. But at any rate, and so this is not just a constitutional question. This is a question of first of all international law, but I think importantly, it's international law that the United States Congress decided to put into statutes. And so in many cases, what you're seeing in the current asylum controversy isn't just a constitutional question. A lot of the strongest claims that asylum seekers are bringing are saying essentially, Congress set out a procedure and set out criteria, and they're saying you, the administration, are doing things that Congress, in some cases, expressly rejected as the way to handle asylum cases. And so basically what you have in these cases, like for example, you mentioned the notion of staying, in Mexico, and I think one of the controversies there is there's a statute that the administration is saying allows this procedure. I think there's a lot of back and forth about whether it allows that procedure, and I think a lot of that's going to play out. So one of the controversies is going to be whether it plays out in a way that courts say the president is doing something violating the statute or not. And then overlaid on that, there is one big important constitutional piece of this, which is due process, which is of course a constitutional aspect, but it's also sometimes directly from the Constitution, the right to be heard, but it's also sometimes something that the Congress has spoken to. So a case I'll mention, this is in a previous, maybe like 2 months ago, it was a hotter topic and has been somewhat superseded by remaining in Mexico, but the administration's tried to set up a situation where you have to go to a port of entry to apply for asylum. And that was blocked by a court, and the U.S. Supreme Court declined to intervene in this, by the way. And the court basically said, hey, Congress passed a statute, and the statute says you can apply for asylum. And the statute actually says you can apply whether or not you're at a port of entry. And so then the court said, wait a minute, you can't make people go to a port of entry. And so, and then that was blocked. And it's a case out of a district court in Northern California and a federal district court. And the Supreme Court declined to step in. And so there's been a series of initiatives like this that have been attacked in similar ways.
Well, from what you're describing, that sounds like a pretty straightforward application of, statutory supremacy. What about, a similar controversy is unaccompanied minors and family separation, right? Because there were court decisions directing the Trump administration to reunite families within a certain amount of time. Was that also a case of being in direct contravention of a statute, or what was the basis for a court stepping in that case?
Well, that was a situation. I think you're talking about the settlement in a case called Flores, and so that was a situation where there was a settlement agreement between the U.S. Government and the advocates for these kids, because there was a lot of concern about the way kids are being treated, and so there was a settlement reached in that case. It set out certain standards having to do with release and care and who kids would be released to and things of that nature. That was a settlement, but there are aspects of settlement that may allow any later administrations, and by I use the term later administrations because this is something that dates back to the 1990s, where the administrations could come in and issue regulations that would supersede the settlement. And so one of the things I think this administration is trying to do is to adopt regulations of that nature. So this is not a case of the administration. This is a well. Let me say what it is instead of what it isn't. I mean, it's a case of the administration being hemmed in by what the federal government, the executive branch, already agreed to do. So at that level, part of what's being attacked or what challenged by the government action is to say, hey, you're violating your own agreement. But then, if Congress, if to the extent that this administration wants to promulgate regulations that essentially supersede the agreement, I think that the argument then is going to be, well, the settlement says you can adopt regulations, but you can't adopt regulations that violate the Constitution, and you can't adopt regulations that treat kids or treat anybody in a way that isn't consistent with statutory parameters. And that's essentially the same kind of argument that is keeping the administration from forcing you to apply for asylum, at a port of entry.
Right. And this is related to an audience question. Do you happen to know how many kids are still separated from their families at this point?
I've seen articles in the last period of time by a week or two saying that no one actually knows exactly, which has got to be troubling. I think the order of magnitude we're talking about is somewhere in I guess 3 figures. I mean, but I've heard reports that it's even more. In other words, there's a couple things going on here. Is that even the family separation policy officially ended as a general matter? I mean, there are still exceptional cases, and part of the issue is how many people that would apply to. There's been issues of reuniting kids with the families, especially when the kids are in U.S. custody, but the parents have been the parents have been deported. I think one of the things we're seeing here, and this is something I'm just reporting something that. I've heard enough to feel it merits mention, is that in some cases, the people who are on the ground implementing these laws are in a position where they're not really sure necessarily what the policy is, how to keep track of these things. And so you could have a situation where people who separated their kids from their parents handled it in a way that it's not clear that this is what happened, and it's hard to know where people are, and of course we've had these tragic situations of kids actually not getting the treatment, medical or the attention that might have prevented several deaths that took place.
Mm-hmm. Well, we only have about 7 minutes left, and okay. We're certainly covering the gamut, but there is one other topic I want to touch on. We mentioned federal versus state, but haven't really had a chance to talk about sanctuary cities, right? Again, it's been a big issue in the news. I'm actually I'm gonna challenge you a little bit because I read your recent article about sanctuary, right? And one of the arguments you made was that one justification for states engaging in things that might be called sanctuary positions, for lack of a better term, right? Where, it's declining to participate in federal immigration policies or procedures as opposed to necessarily affirmatively interfering with them, right? Is that it's important to curb discretion amongst lower level, ICE officers, let's say, and that if that's undermining the rule of law, undermining transparency, states can step in, or maybe arguably should step in, to try and prevent that from happening. So I guess my challenge question to you is isn't that just a case of substituting discretion in one party versus another, right? Instead of having, executive branch officers in ICE making discretionary decisions, you've got states saying, well, our discretion is going to trump yours, and we decide we don't want to participate in this. What would you, how would you respond to that?
Well, so I think there are different kinds of discretion here because it's not as if the state is decide is. I think just to take your hypothetical seriously and sort of play it out, that would I don't think that the state is substituting its discretion for federal discretion. It's not as if the state is saying to the federal government, we think you're engaging in racial profiling, for example. We're not going to do that. Just move over and we're going to arrest different people and we're going to do it in a way that focuses on national security threats or something like that. I don't think that's really what states are doing. They're saying we don't want to be part of a system where discretion might be used in a way in law enforcement that is going to exercise discretion, and so we don't want to be part of that, and we have real concerns about that. And that meaning, how the federal government is essentially identifying people for deportation, and so this was a concern. For example, this was the flip side. The same concern actually worked out in the flip side sort of way when the Obama administration intervened. I use the term intervention in a colloquial sense, sued the state of Arizona for implementing its policy or its actual requirement that people be required to show their identification papers if they were suspected of being in the country illegally. I think the Obama administration is very concerned that this would lead to racial profiling on the ground, and particularly in the context of Sheriff Joe Arpaio in Arizona being under a criminal investigation, but also sued in the context of essentially what I loosely call profiling practices in policing. And so the Obama administration stepped in and said, we think you shouldn't be involved in this. We don't think states should have the power that you can exercise in this way that's going to discriminate. So I think what the states are doing here in the so-called sanctuary or whatever term you want to use legislation is that just as it's right to be concerned that a sheriff, especially serving under a sheriff of the record of Joe Arpaio, just as we're concerned that we have that you are going to exercise this power in a way that is not. I'm not suggesting that every police officer in Arizona would be discriminating, but I am suggesting it would be really hard to tell who is discriminating and who isn't. Mm-hmm. And that's a real problem. Just as we didn't want our Sheriff Arpaio to do that at the time, we don't want to be part of a system where the federal government may be engaging in similar activity. And I think it's important here to understand that what the president's executive order issued in January 2017 did was to say that anyone who is an immigration priority who is in the country unlawfully or and proposes a sort of a threat in the judgment of any public safety officer. And so it's not like it eliminated discretion. It basically just moved the discretion to the field officer level, and it sort of moved the discretion to a zone where you're not going to be able to tell if there really is profiling, what is really going on. And so I think that the sanctuary, these provisions really say we don't want our tax dollars here. A lot of it's actually about tax dollars and priorities used in as part of a system that might go that way. So I think that there's it's not just that it's discretion. It's really it's discretion used in a certain way.
I understand that response. Okay, we're wrapping up here. So
now you see why I teach 100 hours of course material on this. But so
we're definitely cramming it in.
60 minutes.
So now in 60 seconds, I want to get to one more audience question. Looking towards the future, what do you think the odds are, especially now that the Democrats have control of the House of Representatives again, what do you think the odds are of Congress passing comprehensive immigration reform along the lines of the Immigration Reform Act that the Senate passed in 2013 or otherwise? You think it's realistic or still pie in the sky?
I think a lot of this has to do with the relationship between the president and the Republican Party. I think the Republican Party has actually, many parts of the Republican Party have been very receptive to sort of a trade-off that involves giving, what legalization and other reforms. And I think that George W. Bush, for example, I think one of the early proposals was John McCain, Ted Kennedy. And so I think a lot of this has to do with exactly what the distance, if any, is between the Republican Party in Congress and President Trump. I would also say, though, to be truly comprehensive, I think immigration reform really has to think about why people want to feel they have to move to this country, and it really has to have truly comprehensive. Would have to look at questions of our relationship with Latin America and economic development, and create conditions that make people feel that they have a choice to stay home.
All right. Well, I appreciate your take on that and all the questions I've been firing at you over the last hour. Once again, I hope all of you enjoyed this presentation, found it informative. I know I did. Hiroshi, I want to thank you very much for spending this time with us. I hope all of you will be able to join us for our next Distinguished Speaker webinar, which will coincide with the American Bar Association's Law Day, which is May 1st. The theme of Law Day this year is free speech, free press, free society. And in recognition of that, we don't have our final lineup yet, but tentatively, I have as a featured guest Cindy Cohn, who is the Executive Director of the Electronic Frontier Foundation. So please stay tuned for that. And thank you again, Hiroshi. And thanks for all of you behind the scenes who helped make this webinar possible. And have a good afternoon, everyone. Take care.
Thank you.